Hello, everyone. Thank you for coming, and welcome to this week's lecture organized by the Cambridge Arbitration Society and the Lauterpacht Center for International Law. My name is Michail. I'm a board member of the Arbitration Society, and I will be moderating today on its behalf. Before I introduce our speakers, we would like to invite you to follow us on social media, including on Facebook and LinkedIn, where you will find updates on future lectures and other events. Please remember to mute yourself during the lecture, but do send your questions in the chat, and also be welcome to unmute yourself after the lecture if you'd like to ask any questions orally. Please also know that the lecture is being recorded. Now, the topic of the lecture is state corporations, or both state responsibility and security concerns posed by the rise of state enterprises as global actors. This lecture will feature Csaba, Kovacs, who is a solicitor advocate in England and Wales with a long-standing practice and expertise in international commercial and investment arbitration. He is the author of the first in-depth study on attribution in international investment law published by CUArb Law International in 2018. He is also an editor of the Investor State Law Guide. Csaba acted as counsel and sat as arbitrator in arbitrations in a wide variety of sectors, including energy, construction and engineering, aviation, telecommunications, and banking. He holds an LLM degree in international business law from the Central European University. We will also hear from Dr. Michail Dekastros, who is an associate with Sidley Austin LLP. He represents private parties and governments in international dispute settlement with a particular focus on investment treaty arbitration and WTO law. He focuses his experience covers disputes in financial services, oil and gas, mining, gaming, and media sectors, and he practiced under a variety of arbitration rules, including ICSID, UNCITRAL, and LCIA. Michail holds a PhD in international law from the European Institute in Florence, where in his thesis he addressed the rise of sovereign wealth funds in international investment and WTO law. Michail was awarded an LLM from the University of Cambridge in 2011 and was also a visiting researcher at Harvard Law School. Michail will kick off the lecture by addressing regulatory and security concerns posed by the rise of state enterprises, while Csaba will focus on the issues of state responsibility. Michail, please, the floor is yours.
Thank you very much, Michail, and thanks very much to the Cambridge Arbitration Society for extending this kind of invitation to present today. So, yeah, let me start my presentation. Yeah, so can you see my screen now?
Yes.
Okay, great. So in this part of the lecture, I will be addressing the regulatory and security concerns posed by the rise of state-owned entities and the role of international investment law in addressing those concerns. So first, in my presentation, I will provide some background information on state-owned entities and their rise as actors in the international economic system. I will explain the regulatory concerns of host states when those state-owned entities invest in their territory. And then I will turn into international investment law and how it can mediate between this tension between state-owned entities and host states. In doing so, I will look into the standing of state-owned entities under international investment law, the substantive protection that they might benefit from under bilateral investment treaties and FTAs, and also the role of national security exceptions and how host states can use those exceptions to constrain the activities of state-owned entities. So first, some background information. The last several decades, and the last decade in particular, we have seen a very important growth in the number, capitalization, and influence of state-owned enterprises that engage in overseas investment. This usually takes the form of state-owned companies investing abroad, sovereign wealth funds, or some other similar hybrid sovereign commercial vehicles. States invest for a variety of reasons. We cannot group them into one category, but sometimes it's for strategic reasons, other times it's for social, political, or public policy purposes, or simply just in the pursuit of profit. In 2014, state-owned entities accounted for more than 23% of the Fortune Global 500 companies. China is obviously the main driver behind this phenomenon, and there are more than 150,000 Chinese state-owned entities, and many of them actively invest beyond China. At the same time, we have witnessed the rise of sovereign wealth funds. Recent estimates indicate that sovereign wealth funds hold assets of more than $5 trillion US. Some of the more important sovereign wealth funds are outlined in the next bullet point, and those sovereign wealth funds as well have been pursuing mostly passive but sometimes active investments abroad. And another interesting statistic is that we've seen more and more disputes where a state or state-owned entity is involved. For instance, in the latest ICC dispute resolution report, it was noted that 20% of new cases involve states or state entities, representing a 6 to 7 increase in the number of such arbitrations. And these are just commercial arbitrations. In delineating this problem, what is the problem? Why state-owned entities have caused concern into the international economic system? Well, the host states are a little bit concerned about the objectives of the state-owned entities. Sometimes state-owned entities will pursue political objectives rather than purely commercial objectives. Other times, they might pose national security risks due to their ties to foreign governments. For instance, I'm pretty sure everyone knows Huawei's investment in 5G networks and how that played out. Sorry, can you still see my presentation? Can you hear me?
Not anymore. We cannot see the presentation.
Yeah. How about now?
Still, we cannot see the presentation. We can see you and hear you?
Okay, let me.
Yes, we can see the presentation now.
Yeah, okay. And another concern is that state-owned entities might engage in anti-competitive behavior. On the other hand, state-owned entities as well have some concerns about how they will be treated in the territory of host states. For instance, they fear that they might be subject to discriminatory or arbitrary governmental, regulatory, or administrative treatment motivated by political considerations rather than a genuine cause, and this might restrict their activities or force them to divest. However, the fears of host states are probably a little bit overblown. Most of the regulatory concerns raised by state-owned entities are not dissimilar to concerns surrounding other market entities. Yet, we see a trend in establishing new barriers into the investment of state-owned entities. For instance, many states, the US and the EU in particular, over the last years, have addressed the rise of sovereign wealth funds and state-owned entities through the so-called foreign investment screening mechanisms. These mechanisms operate preventively and at the border, and they review and sometimes block sovereign investment on an ad hoc basis. And so the main purpose of this presentation today is to see whether this approach is lawful under international investment law, whether state-owned entities can have recourse to investment arbitration to protect themselves against such practices, and what is the role of national security exceptions? Is there an argument to be made by host states that these foreign investment screening mechanisms are justified under these exceptions? And And so international investment law does have a significant role to play, mostly at three levels. At the dispositional levels, as will be explained below later, investment tribunals do have jurisdiction over the resolution of disputes between state-owned entities and host states. At the pre-establishment level, a considerable number of BITs restrict the discretion of host states to block the admission of investments by state-owned entities. And at the post-establishment levels, some BITs also place limits on the state's ability to invoke national security exceptions. So with respect to the first issue, whether state-owned entities can bring investment claims against host states, as a starting point, we need to look at the text of BITs or FTAs, international investment agreements, more generally, and to examine whether these cover state-owned entities in their definitions of investors. So most investment treaties actually do not take a clear position on this issue. However, the formulations they use, typically that the definition of investor includes legal persons or juridical entities, would normally suffice to cover state-owned and the activities of state-owned entities. And some investment treaties actually expressly mention states and their some subdivisions as potential investors. An example is the 2004 US model BIT here. With respect now to ICSID arbitrations, there is an additional layer of consent that needs to be fulfilled. So Article 25.2b of the ICSID Convention provides a definition of investors. And under that definition, nationals of another contracting state and juridical persons are covered. So this definition appears to not exclude state-owned entities. It has been suggested in the past in the literature that the ICSID Convention was not designed to offer treaty protection to government agencies because the ICSID Convention was designed to promote and encourage private international investment. However, a look at the commentary of the preliminary draft of the ICSID Convention suggests otherwise. It appears that the drafters of the ICSID Convention had considered the possibility and they decided not to restrict access to the ICSID arbitration to state-owned entities. And in fact, there is this issue has been directly addressed in a couple of cases. The first of which was the CSOB versus Slovakia case. That dispute arose from an attempt to privatize and consolidate CSOB, a former state bank. The CSOB tribunal proceeded from the premise that ICSID does not have jurisdiction over disputes between one or more contracting states, and then had to examine whether CSOB had to be considered as a part of the state, essentially. And in the absence of any express guidance in the ICSID Convention, the tribunal established a standard for determining whether a state company qualifies as a national of another contracting state. This is a so-called Bros test, and which is as follows. For the purposes of the convention, a mixed economic company or government-owned corporation should not be disqualified unless it is acting as an agent for the government or is discharging an essentially governmental function. And in applying this standard to the facts of the case, the tribunal decided that CSOB was not actually was not to be considered as a state entity. And in doing so, the tribunal relied on a nature test that examines the nature of the transactions rather than their purpose. The tribunal concluded that although CSOB was promoting and implementing governmental policies or purposes, the activities at issue, banking and trading operations, were essentially commercial rather than governmental in nature, and upheld jurisdiction ratione personae. So having established that BITs and the ICSID Convention enable investors to bring, enable state-owned entities to bring claims against the host states, we're now going to turn into state-owned entities and the substantive protection they might enjoy at the pre-establishment level of an investment. The pre-establishment level is, before an investor has actually incorporated or established an entity in the territory of the host state. And we are looking at the pre-establishment level because, as I explained earlier, these foreign investment screening mechanisms operate at the pre-establishment level, at the border, and they can block state-owned entity investments. So with respect to pre-establishment, we have two types of international investment agreements. First, we have the so-called limited entry BITs. This is the majority of BITs. And those BITs include an obligation only to promote investments, but not to automatically admit all of them. However, there are a few, I think about 15% of BITs, the so-called liberalization BITs, that go further than that. In these BITs, the contracting states extend the national treatment obligation to the pre-establishment stage of the investment, giving thus prospective investors the right to be admitted and to maintain a permanent establishment in the territory of the recipient state. The United States, Canada, and more recently Japan, Finland, and Norway have been pursuing this model. Under these liberalization BITs, the state-owned entities actually do have the right to move capital and to set up a permanent commercial presence in the host states. And therefore, foreign investment screening mechanisms that have this very wide mandate would prima facie violate the commitments undertaken under these agreements. Because these mechanisms provide preferential treatment to domestic investors, because as the state-owned entities, because domestic investors do not have to go through the same process in order to proceed with their investments. And finally, I'm going to turn into national security exceptions. So since we've established that under liberalization BITs, these foreign investment screening mechanisms might potentially be in breach of the treaty, we have to examine whether the exceptions under those investment agreements could actually ex post justify the existence of such mechanisms. Most BITs do not actually contain national security exceptions. The older generation BITs do not contain such exceptions. But more recently, and especially after the Argentinian sovereign debt crisis, most states have tried to include national security exceptions in their BITs. The formulation of the national security exceptions under those treaties is quite different, and there is a varying degree of deference that is provided to the host states. So, as I said, some BITs do not contain a national security exception. Others lay down necessity as an objective standard, and many of them contain the so-called self-judging exceptions. And so, for the purpose of this presentation, I'm going to examine these self-judging exceptions and actually looking into how self-judging they are. The first example of such a self-judging exception was in Article 21 of the WTO agreement on trade in goods, and that formulation has then migrated into the BITs. An example is, for instance, the US Bahrain BIT, and the text would read as follows: this treaty shall preclude a party from applying a measure which it considers necessary. And many commentators and many states for a number of years, they had suggested that this provides host states with an absolute degree of deference. Whatever the state thinks is a national security concern, then that measure should be excluded from any sort of scrutiny. The result of such an interpretation would be that the dispute is non-justiciable, and so this had not been tested for a number of years. It has recently been examined by the WTO, who said that these exceptions are not 100% self-judging, and that there has to be some sort of review of the state's declaration that the measure has been taken in pursuit of a national security objectives. And indeed, national security exceptions were never envisaged as escape valves for commercial considerations. And since we are in the Lauterpacht Center, the Judge Sir Herst Lauterpacht has made very eloquently that point in the Norwegian loans case, albeit in a different context, when he explained that such an interpretation would render a legal obligation null and void. If a court of law cannot examine the existence of the obligation itself, then the obligation ceases to be a legal obligation. It's merely a declaration of a political principle. And since those exceptions are not entirely self-judging, then the obvious question is, what is the standard to be applied when examining the invocation of those exceptions? And this question is still open. Several different formulations have been proposed, but at the very least, everyone agrees that there has to be some sort of good faith analysis of the invocation of state. For instance, if a state considers that a certain measure serves national security, there has to be some sort of reasonable nexus between the measure and the objective it pursues. And often, when some of these state-owned entities' investments are blocked by the foreign investment screening mechanisms, the justification provided is a little bit dubious. It's not necessarily connected to national security. And we've seen quite a few examples of the US doing exactly this in the past 4 years. And so I would submit that under international investment law, as it stands, frivolous or abusive invocations of national security exceptions to promote political considerations or even further protectionisms have to be rejected, and that foreign investment screening mechanisms are difficult to justify even under a self-judging national security exception. So this concludes my presentation. If you have any questions before Csaba takes the floor, please let me know.
If I may, Michail, actually, I have a question. The discrimination provisions typically are the national treatment and the most favored nation treatment in these BITs, and often there is a question about their scope, whether their scope extends to the establishment of the investment as well. What if they have a narrow scope in terms of so their scope is covers only post-establishment, so management, enjoyment, disposal, and so on? Could you then say that the discriminatory treatment falls foul of international law under the FET provision?
I think in such a case, you wouldn't be able to say that, in abstracto, a foreign investment screening mechanism falls foul of that provision. But if you look at the mandate of these foreign investment screening mechanisms, very often have the competence, have the authority to order an investor to divest from the host state, even after the investment has been made. For instance, CFIUS in the United States can actually do that, and I think it has done that in 1 or 2 cases. So even at the post-establishment, level, there would be still scope to argue that parts of the mandate of these foreign investment screening mechanisms violate commitments under international investment treaties.
Thank you, Michail. Shall I continue if there are no further questions?
Yes, I understand there are no further questions at the moment, so please, you can ask them in the chat and we will address them at the end. And for now, Csaba, please move on with your presentation.
Thank you, and also thank you for the Cambridge Arbitration Society and the Lauterpacht Center for the invitation. I haven't prepared slides, so you just have to bear with me for 25 minutes or so. I will address today's topic from the perspective of state responsibility, the international law responsibility of the state, and the notion of attribution, mainly the IRC articles 4, 5, 8, as they are most frequently invoked in practice. As a collective subject of international law, the state operates through a multitude of organs and instrumentalities, and they have distinct rights and obligations for which they alone can be sued and are responsible under internal law. This, of course, applies to state enterprises as well. However, for the purposes of the international law of state responsibility, the state is treated as a unity, which is consistent with its recognition as a single legal person in international law. Now, the concept of attribution bridges the gap between these two conflicting realities. On the one hand, the unity of the state, and on the other hand, the multitude of its organs and instrumentalities. Attribution is deployed to answer the question of which person should be considered as acting on behalf of the state, or in other words, what constitutes an act of the state for the purposes of the state's international law responsibility. Attribution serves to identify the circumstances in which it is justified to attribute to the host state a conduct which is alleged to be in breach of that state's obligations for today's purposes under an international investment agreement. This is achieved by analysis of the subject involved in the contested conduct, its connection to the host state, and the capacity in which it performed the act in question. This analysis is necessary because, in principle, the conduct of private persons is not attributable to the state. And also more relevant for today's topic, international law acknowledges, of course, the separate corporate personality of state enterprises. That said, an internal law designation of a state enterprise is not determinative for the issue of attribution as a condition of state responsibility, because international law looks beyond the formal legal status of a state enterprise and considers the factual reality in line with the principle of effectiveness. In terms of the normative framework, the attribution rules of the IRC articles on the responsibility of states for intentionally wrongful acts codify customary international law and are widely applied in the absence of special provisions in an applicable treaty by the investor state arbitration tribunals. Actually, in most cases, the fallback is to the IRC articles because these BITs or multilateral investment treaties, they do not contain special attribution rules. The exception is, for instance, the Energy Charter Treaty 22.3 or BITs based on US model BITs, which contain a special rule requiring the state to ensure that its state enterprises comply with the treaty obligations. Now, turning to the IRC articles, the most frequently invoked rules 4, 5, 8. The test is to examine what is the extent of the link of a person or entity to the state. And such a link can result from the fact that the person performing the act is part of the state's organic structure. This is the case of Article 4. Or exercises governmental powers specific to the state in relation with the act, even if it's a separate entity. This is the case of Article 5, or if it acts under the direct control or instructions of or under direction of control of the state. This is the case, even if it's a private party, this is the case of Article 8. A certain degree of flexibility is embedded in the IRC articles attribution rules. As an investment treaty tribunal put it, the notion of, in relation to SOEs actually, the notion of governmental authority is intended to be a flexible one, not amenable to general definition in advance. And the elements that would go in its definition in particular cases would be a mixture of fact, law, and practice. Moreover, and the point is of some importance, it is not the case the same answer would necessarily emerge on every occasion. In some of its activities, a state enterprise might fall on one side of the line, in others on the other. The ILC articles, and in particular Article 4, entitled Conduct of Organs of a State, use the notion of state organ in a broader sense, covering all entities that make up the organization of the state and act on its behalf. Even if an entity does not have formal status of a state organ under internal law, the substantive test of international law may still lead to a classification of state organ under international law. In an investment dispute, this is an important distinction, because once it is established that an entity is an organ of the state, a state cannot argue that the commercial conduct of a state organ is not attributable to it. Now, state enterprises are unlikely to have the state organ status under internal law. A state enterprise, separate corporate legal personality, establishes a strong yet rebuttable presumption that it's not a state organ. The concept of de facto state organs can be used to overturn that presumption that the state enterprise is not a state organ because of its separate personality. The concept was pleaded in several cases, but it hasn't gained much traction in investment arbitration jurisprudence. And in my view, this is unsurprising due to the exceptional nature of this qualification. The International Court of Justice formulated a test in the Bosnian genocide case in the following terms: to equate persons or entities with state organs when they do not have that status under internal law must be exceptional, for it requires proof of a particularly great degree of state control over them, end quote. This test was described as a complete dependence test. The investment tribunals endorsed the ICJ test, but its application to SOEs remains very limited to date. The tribunal in Union Fenosa in Egypt noted, to quote, circumstances sufficient to connote the status of an organ of a state to a separate legal person must be extraordinary, involving functions and powers considered to be as quintessentially powers of statehood, such as those exercised by police authorities. In the words of the tribunal in Almasz in Poland, to quote, internal status does not necessarily imply that an entity is not a state organ if other factors, such as the performance of core governmental functions, direct day-to-day subordination to central government, or lack of all operational autonomy, point the other way, end quote. In this case, the Almasz in Poland case, the tribunal recognized that the performance of public functions or the exercise of public powers by a state entity may lead to an inference that that entity is a state organ, but it noted that such an inference cannot be drawn when the entity engages on its own account in commercial transactions, even if these are important to the national economy. In the recent case, Venezuela-US, formerly Anadarko and Venezuela, the claimant asserted that Petróleo de Venezuela was a de facto state organ because it was used by the state to control and operate all aspects of hydrocarbon exploration, development, production, and sale in Venezuela. In other words, it was a monopoly. Tribunal did not accept the state's monopoly over hydrocarbon resources meant that PDVSA was a state organ. It noted that PDVSA and its affiliates involved in the dispute engaged predominantly in seemingly commercial transactions, and they were and operated as private entities under domestic law. So a de facto organ qualification implies a degree of inconsistency in the regulatory framework applicable to the state entity, which is not something of which tribunals can be easily persuaded. This is why we rarely see a de facto state organ qualification positively upheld in practice. In Union Fenosa in Egypt, the tribunal noted that state ownership of entities and their involvement in the development of state-owned natural resource necessarily implicate public sector concerns. But participation in the public sector is not the same thing as being integral to the state apparatus. There may be in practice evidentiary factors that point to a subordinate relationship between an SOE and the state. For example, in Flamingo duty-free in Poland, the tribunal found that the Polish airport state enterprise, or PPL, was a de facto state organ largely based on public statements made by the Secretary of the State before the Polish Parliament that PPL functioned within the structure of the Ministry of Transport, its shareholder, which through PPL was participating in the modernization of the Warsaw-Chopin Airport. Now, contrast this with the finding in Stauren, Latvia, in which the tribunal found that the state-owned owner and operator of the Riga International Airport enjoyed operational autonomy from the state, and the role played by the Ministry of Transport was not unlike that ordinarily played by the shareholder of any private company, and therefore its separate legal personality could not be disregarded so as to treat it as a de facto organ of the state. There is consensus among tribunals that state ownership or control of shareholding does not convert a state enterprise into a state organ. In most cases, the separate corporate legal personality and the private law organization of a SOE were sufficient for tribunals to consider that those SOEs did not act on behalf of the state and were not therefore state organs. In Ampal and Egypt, the tribunal disregarded the separate corporate personality of the Egyptian General Petroleum Corporation, or EGPC, based on its function, alluding to its importance to the country's hydrocarbon resources, its supervision by the Minister of Petroleum. For instance, the board minutes had to be ratified by the Minister of Petroleum, and its board composition. And based on these internal law factors, EGPC was considered a corporate entity within the overall structure of the Ministry of Petroleum. A couple of years later, in Union Fenosa in Egypt, the tribunal noted actually that distinguished the facts from those in Ampal. This case also concerned the same company, Egyptian General Petroleum Corporation, and it said that actually the Ampal decision did not explain why these factors showed that the EGPC was part of the structure of the state so as to deny its autonomous existence. It said that these factors had analogues in private companies that clearly do not have the effect of subjecting shareholders to liability for corporate obligations. The Union Fenosa Tribunal added that the state's power to appoint and dismiss management did not reveal a lack of autonomy on the part of the state enterprise. It said that private parent corporations routinely appoint their officers as members of the boards of directors of their wholly owned subsidiaries without thereby losing shareholder immunity from liability. The Union Fenosa Tribunal applied a functional test, or what I would call an equivalency test, essentially checking whether EGPC exercised functions and powers considered to be as quintessentially powers of statehood, and whether the invoked connecting factors had correspondence in private companies. The tribunal concluded that EGPC was not an organ with respect to the sale purchase agreement because private companies manage private natural gas resources as a matter of course, and notwithstanding the fact that governmental export activities, governmental export approval may be required, the act of exporting natural gas in any form is not by its own nature a sovereign act. Caution must be exercised in reading too much into the attribution of the acts of EGPC in Ampal. Indeed, the context may explain the different conclusions concerning the attribution of the conduct of EGPC in Ampal and the later case Union Fenosa. The underlying transaction in Ampal occurred in furtherance of an interstate agreement between Egypt and Israel, while in Union Fenosa the transaction concerned gas exports based on a sale purchase agreement with no interstate arrangement in the backdrop. Also in Ampal, according to a Council of Ministers resolution, EGPC was expressly acting as an agent of the state in concluding the gas supply agreement. Jurisprudence shows that the strategic importance of an asset or activity to the national economy in itself is insufficient to attribute the conduct of an SOE to the state. See, for instance, the Suez Canal Authority, which Suez Canal is obviously a strategic asset to Egypt, for Egypt, in Yandenul in Egypt. That said, in light of the importance of an asset or an activity, there may be internal law internal law factors which evidence a high degree of integration in the overall state structure, in which case tribunals may disregard a separate corporate legal personality and apply the Article 4 test. It is important to emphasize that these internal law factors are not considered in isolation. The assessment of the entity's relationship with the state requires a holistic approach. An approach reduced to a single criterion can be inconclusive, also because as part of the overall assessment of the internal law status of an entity, an SOE, tribunals have placed different weight on the same internal law factors. There are many ways in which a state can conduct its activities, can organize its relationship with the investors. The international law criteria for identifying state organs cannot be exhaustive or mechanical. Nevertheless, from the jurisprudence, I extracted as general criteria some connecting factors that can be applied to the varied circumstances of each case. And these are non-exhaustive, as I said, establishment by law, lack of separate legal personality under internal law, lack of institutional operational independence, performance of core governmental functions, lack of separate patrimony, lack of financial autonomy, or operation on public law principles, the entity being subject to judicial review or direct governmental oversight. A whole state may act through state enterprises also which are not part of the state's organic structure. This is more likely to be the case, actually. This warrants an examination of the attribution of the conduct of state enterprise under ISA Article 5, which is entitled Conduct of Persons or Entities Exercising Elements of Governmental Authority. And this captures the situation where when the separate entity is utilized by the state based on its internal law as a means or vehicle to exercise governmental authority. The test is whether the impugned act was an exercise of a delegated governmental function in the whole state. The same governmental function may be performed in some state directly by state organs, and in other states may be delegated to separate entities. And ISA Article 5 was designed to ensure consistency in the state's international law responsibility while acknowledging this diversity of state organization. The jurisprudence demonstrates that tribunals differentiate between the two prongs of the rule, namely delegation on one hand and the exercise of the governmental function on the other hand, without much difficulty, in the sense that if the state enterprise is empowered to exercise elements of governmental authority, but the contested act is not in fact in exercise of such power, then the act is not attributable to the state. For example, in AMTO and Ukraine, the tribunal considered the conduct of the national nuclear power generating company, Energoatom, and it accepted that Energoatom was a strategically significant state entity, obviously dealing with nuclear energy. It was in close communication with the state, but it stated, to quote, the payment, this was a contested conduct, the payment or non-payment by a state entity of contractual debts owed to a service provider involves no exercise of sovereign authority or puissance publique and cannot be attributed to Ukraine. The ISC considered that it was not for international law to define in advance what conduct should be regarded as public or governmental, because the line between public and private varies continually over time within and between different countries. Hence, the notion of governmental authority was meant to be applied in practice as a flexible concept, tailored to the facts of each case, and an investment arbitration jurisprudence indeed reflects this premise. Professor Crawford articulated this test in the following terms. If a private person can perform the function without the government's permission, the function is not to be considered governmental. End quote. That said, commercial activity is often subject to governmental approval in regulated sectors, without that approval automatically attracting a governmental connotation. For example, in Union Fenosa and Egypt, the tribunal noted that notwithstanding that the governmental export approval may be required, the act of exporting natural gas is not by its own nature a sovereign act. On the other hand, it would not be disputed that a right to grant a concession of natural resources is a governmental function. For Article 5, the state immunity concepts of acta iure gestionis and acta iure imperi are applied in investment arbitration jurisprudence to differentiate between governmental and commercial acts. The acta iure imperi involve the state's use of its police powers, public prerogatives, puissance publique, or imperium, coercive enforcement powers. In relation to the state enterprise, the use of puissance publique necessarily means acts which exceed the normal course of conduct of a state shareholder or a contracting party to a state contract. Now, since Maffezzini and Spain, many tribunals have applied a functional test examining whether the act in question is governmental in nature or is otherwise normally reserved to the state, or by its nature is not usually carried out by private businesses or individuals. The question of whether the purpose of the impugned act should be taken into account in distinguishing between commercial and governmental acts was in fact one of the most disputed issues also in the drafting of the UN Convention on Jurisdictional Immunities of States and their property, which is still not in force, which was adopted some years after the ISC articles. This lack of consensus actually indicates, in my view, that the use of the purposive test in determining governmental acts is unlikely to gain universal acceptance. So where does this governmental commercial dichotomy leave us? Could a state effectively avoid responsibility under international law by exercising governmental authority through contractual or commercial means? In my view, if the state enterprise's impugned act is in the exercise of powers available to private entities operating in normal open market conditions, then that act could be presumed to be commercial unless proven otherwise, even if that act serves a general or public interest. Now, conversely, if an SOE's impugned act is in the exercise of powers concerning an asset or activity reserved to the state, that act should not necessarily be regarded as commercial just because the underlying power is exercised through contractual means or commercial means such as public tender. The equivalence test used in Union Financière in Egypt could be used to test these presumptions. The question is, can a private party act in a similar manner as the SOE did in relation to the impugned act? And of course, these presumptions would not discharge the claimant from establishing the specific delegation of the governmental power at issue and its actual exercise as required by IC Article 5. There is a minority view in the jurisprudence, for instance, the Arbitration Alvarez in Intertrade and the Czech Republic, or Nobiter in Garanti Cosa in Turkmenistan, that if the subject matter of the contract relates to a core governmental function, in Intertrade this was the management of state-owned forests, or in Garanti it was the road and bridge construction, then the state entity's impugned act relating to that contract is in the exercise of governmental authority. Now, in my view, the rebuttable presumptions that I mentioned and the equivalence tests would add some certainty and predictability in these scenarios without compromising the necessary flexibility demanded by the circumstances of each case. In investment cases involving projects of strategic importance, tribunals showed an understanding of governmental involvement, some tolerance, degree of tolerance, without necessarily attributing the actions of an SOE to a state. In a minority of cases, for example, FNW oil interests in Trinidad and Tobago, which involved contract negotiations aborted by Petrotrin, the strategic importance of the project in question and the involvement of various governmental officials in the process conducted by the SOE were sufficient to conclude that the project was not a mere commercial deal, and therefore the contested act of the SOE was attributable to the state. Often in projects of strategic importance, such as contracts concluded by national companies for exploitation of hydrocarbons, the internal law applicable to the SOE establishes direct control mechanisms that may justify the attribution of the conduct of SOE to the state. For example, in Encana in Ecuador, the statutory supervision of Petroecuador's commercial conduct by the Attorney General of Ecuador was sufficient for the tribunal to attribute Petroecuador's refusal to renegotiate the contract to Ecuador. In some cases, the parties' contract itself may reflect an understanding as to the issue of governmental authority. This was the case in Altamimi and Oman, where the contract provided that the state enterprise, the Oman Mining Company, would use its best endeavors to obtain the requisite environmental operating permits, and the lease agreement would enter into use upon obtaining those permits. This was held to evidence a contractual understanding that the Omani mining company did not exercise delegated governmental authority in relation to the contract, but acted as a commercial intermediary between the claimant's law vehicle and the Omani authorities, exercising relevant government authority. Now, conversely, the other scenario, in Kaki and Pakistan, the state enterprise Lakra committed under a contract that no state organ would expropriate Karki's assets and pledged to secure the issuance of a sovereign guarantee. The tribunal held that such pledges could not legitimately have been made by a purely private sector entity. And just very quickly on IRC Article 8, while the attribution test concerning the state instrumentalities is focused on the de jure extension of the state authority to separate entities, the de facto extension of state activity is governed by Article 8. And this deals with the attribution of the conduct, in fact, carried out on the instructions of a state or under its direction or control. The question to be asked is whether the SOE would have committed the impugned acts without the specific controlling intervention of the state. In relation to SOE, actually, the IRC commentary makes it clear that the shareholder control is insufficient for attribution purposes. The added requirement is the exercise of public powers by the state enterprise or the state's use of its shareholder powers, ownership interest, specifically in order to achieve a particular result. In EDF and Romania, the tribunal emphasized that the test of executive controls, so when the state shareholder goes beyond the debt conduct of an ordinary shareholder, this test is looks at the state enterprise's own commercial interest is necessarily subjective, because the tribunal is not in a position to make a judgment on what is objectively in the best interest of a company for the purposes of attribution. So in reviewing whether the decision-making process of an SOE was autonomous and based on its own interest, tribunals typically check if there were commercial circumstances supporting that decision, and if so, the conduct is not attributable to the state. To conclude, the attribution rules require a degree of flexibility in practice, and this is due to the diversity of state conduct. We are likely to see more investment tribunals that anchor their reasoning in the attribution rules, as Professor Crawford put it, since we are in Cambridge. A bit like drowning men might grab a stick at sea in the hope of having certainty. Thank you.
Thank you very much, Csaba, and Michail as well. Very, very detailed and very interesting lectures. And we do have a couple of questions which are in the chat, but I will read them for the benefit of those who are not looking at the chat. So the first question is to Csaba, and it is: do you believe that it is correct from a doctrinal perspective to use the ILC attribution rules when assessing the jurisdiction ratione persona of a tribunal when an SOE acts as an investor by applying the Broach's test, given that the question of act of state and what is a contracting state are different legal questions?
Yes, so the Broach's test is actually the flip side of Article 5. It is not per se an attribution test. It is a test which is elaborated by the architect of the Exit Convention. The test looks at whether the SOE acts as an agent of the state or discharges essentially governmental function. But technically speaking, it is not. It is very similar in application to ISC Article 5, but it is not an ISC Article 5 test. And of course, flipping that to state responsibility issues as well, that issue also comes up, whether when an SOE is a contracting party, should a jurisdictional question of ratione persone be determined based on attribution rules, and should the attribution issue be looked at the jurisdictional stage? And the consistent line of jurisprudence that emerged that this is rather a merits issue, and in a jurisdictional stage you only look at sort of a prima facie test just to examine whether there are any links, generally speaking, with the state. If there are no links whatsoever, then you might as well decide that issue there. But if there are links, those links are better examined at the merit stage with a fuller inquiry of all the facts.
Thank you. And there's actually a second part of this question. Do you think that interpretations of investment tribunals on the LC articles when assessing responsibility questions are on the average favorable, neutral, or negative for developing states that heavily rely on SOEs as part of their national development strategies?
Not at all. In fact, the tribunals, I mean, often you would have to look at the background of the arbitrator. What I noticed that arbitrators from a PIL background tend to interpret, public international law background, tend to interpret these rules more narrowly. Arbitrators from a more commercial background might take a more broader interpretation. The recent PDVSA case, actually, the one that I mentioned, Anadarko and Venezuela, is actually a good example, because it was PDVSA, it's a state monopoly, and you're dealing with basically a socialist economy. And the tribunal chaired by Judge Tomka said that with the exception of specific conduct, which was if I'm not mistaken, based on ISC Article 8, and that was the direction to pay dividends only to an affiliate of Petrobras and not to the claimants. So PDVSA was considered as outside of the state apparatus, despite the fact that you're dealing with a tightly controlled economy. And actually a US court in Delaware, in the Crystal X enforcement procedure, arrived at the opposite conclusion.
That is very interesting indeed. And we have a question to both speakers, which is, how would you address, how would you, I guess I could address the new EU-China FTA in relation to the regulation of Chinese SOEs economic activities, e.g. screening mechanisms, attribution and standing, in case you have had a chance to see the new FTA?
I mean, I've had a quick look. I haven't looked at this in detail, but I think, well, there's no investment protection chapter yet. So, there might never be one. So we don't know if there's going to be investor-state dispute settlement. And I think screening mechanisms for national security purposes are also excluded. There are no commitments with respect to the screening mechanism. So, there's a positive list of commitments. Some sectors have been added, but anything that falls under, the mandate of screening mechanisms is excluded. I don't know about attribution. I'm not sure if the agreement.
Yeah, I have nothing to add. That my knowledge is also, just like Michail has mentioned, that the investment chapter is still under negotiation. Only a trade deal was enacted.
Right. Yes, this makes sense. And we have one final question, which is, do you think that a host state has a defense of countermeasures to avoid responsibility for its actions towards an investor who is an SOE, if, for example, the host state considers that the home state of the investor breached its separate international law obligations towards the host state?
Michail, I think this one is for you.
Yeah. So I think it's a very interesting question. It's a little bit difficult to answer in the abstract. I think to be able to, apply a measure as a countermeasure against an entity, that entity would have to be some sort of state organ. But if it is a state organ, then it's difficult to see, how it would also be an investor, given the test we outlined earlier. I suppose theoretically, there could be a situation where some sort of state organ is engaged in some sort of commercial activity, and I guess in that scenario, even though that entity would have sovereign immunities, the state might be able to, I don't know, take some measure like seize property or something that could lead to an arbitration. So I think theoretically yes, maybe, but it's like a very hypothetical scenario. Like and we would have to look at the facts of the case and determine the exact nature of the investor or entity involved in the dispute.
Thank you. I hope this answers, and thank you very much again to both of our wonderful speakers, to Michail and to Csaba, for joining. And again, apologies for the link situation. I hope everyone has enjoyed the lecture, and we will post the recording online so that everyone who did not have a chance to watch this today will have a chance to watch it later. Thank you very much, and goodbye.
Thank you.
Thank you, everyone.
Bye.
Have a good evening.